This is the third time I've tried to do an introduction to this video. I'm just going to keep this one. So, I want to talk about bad faith. The reason I'm doing this in a video format is because I've had conversations like this with different employees. In the words of the great American philosophers, Rage Against the Machine, you got to know your enemy. And the more we can understand how the insurance company is thinking and what's motivating them to make the decisions they make, the better we're going to be at our jobs. And this concept of bad faith is a huge one. It comes into every decision they make. So when we talk about bad faith, what we're really talking about is every contract, anytime there's a contract entered into, there is what's called a covenant of good faith and fair dealing, which just means each party will refrain from doing something that harms the other party. Now, in an insurance contract, it's even a little more extreme. There's the covenant of good faith and fair dealing, but if that is breached, then they actually have a tort where you can get punitive damages. And I really want to talk more about why it exists and kind of understand philosophically the reasoning behind it, and then also how we can use it to our advantage. So the idea with bad faith is, let's say you had someone has an insurance policy of $15,000, and that person hits someone who is now a paraplegic, right? They can't walk anymore. There's never a scenario where it doesn't make sense for the insurance just to pay that $15,000 and just make the case go away. They'll save money on the defense lawyer fees if they do that. But now let's imagine a scenario where someone gets in an accident and they break both their arms. And then the party that harmed them, the party that hit them, has an insurance policy of $100,000. Well, I think I think almost every single time you would take that to trial. But let's say the insurance company does some sort of, analysis. They look at every single jury verdict that's ever been, and they say, well, actually, 1 out of every 6,000 cases like this that go to trial, we would get a defense verdict. So that means there's something about the plaintiff, there's something about that person that is just so unlikable that a jury washes them out. Well, what that would end up doing is making the insurance company make a decision that our max liability, if any of these cases goes to trial, is $100,000, right? That's the max we're ever going to have to pay. So rather than just pay the $100,000, we'll just let the case go to trial. They get a judgment. We protect our insured only up to $100,000, and then they're on the hook for all the rest. Well, imagine all the trials that go forward where there's $700,000 verdict, $600,000 verdict, even a $300,000 verdict. The excess of that judgment falls on the insured, right? The person who hit our client. So in all of those cases, it makes no difference to the insurance company if they can just have that one time where they get a full defense, right? They have to pay zero. It's worth it for them to just, we'll take the case to trial, and anything that's in excess falls on the insured. It doesn't matter to us. And that's how insurance companies would operate. That's the whole reason this law exists, is to prevent this from happening. So the idea is when we make a demand on a defendant's insurance company, if this is why a lot of times if we have a case where there's severe injuries and there's only a $15,000 policy, they'll turn around and give that to us right away. Because if they don't, if we've given them a reasonable opportunity to settle within the policy limits and they don't, that policy is forever what we call an open policy. Now, this is a huge deal if we get an open policy. Let's say we have a claim, or a client, I should never say claim. We have a client and they broke both their legs and there's only a $50,000 policy, and we make a demand and they refuse that demand. Then it could just be out of laziness. It could be out of oversight. It could be out of a lot of things, right? We give them 30 days to respond and they don't. And then they come back and say, well, we'll give you just meds, $35,000. Okay, they've denied our demand to settle within the policy limits. Now we have an open policy. What's amazing for us as plaintiffs' lawyers is once the policy is open, they could come back the next day and say, no, we'll pay the policy, Nope, we're not going to do it. So the policy is open, it's forever open. And so we can march forward with litigation, and we'll just take that case to trial and get more than the policy. So this is phenomenal for us because a lawyer that I know who's really good, he's actually taught me how to pick a jury. He was kind of a mentor when I was first starting out. He recently had a case in LA. He met this gal actually at his gym, and she was explaining that she had been in this really atrocious accident. I mean, she had to get plastic surgery on her face and all this stuff. So he hopped in and he immediately demanded the policy. It was $1 million policy, and they denied it. And by the way, this is much more likely to happen with big injury cases with big insurance policies. They're much more likely to deny it, right? Because there's just so much to take into account. But they gave a reasonable demand. They denied it. And then the case went to trial. I have the trial transcripts, and the gentleman I know asked the jury for, I think, like $40 million or something. But he ended up getting $25 million. But what's interesting is you read the defense's closing argument, and they say, you should award, we're not denying that she's injured, you should award $1 million. So his suggestion to the jury was exactly the insurance policy. And they came back with $25 million. And they collected all of that because we had an open policy. The way it would work is the first $1 million comes from the insurance company. Now the remaining $24 million is a judgment. It's an excess judgment. That's a term we'll say sometimes. And if you look at our demand letters, we say, we'll get an excess judgment, right, against your insured. In this case is the Asian doctor gentleman. So now the insurance company pays the first $1 million. There's a $24 million judgment against this doctor. So the way this works is in every contract, you can have an assignment of rights, right? So if I have a contract for exclusive, there's a shirt manufacturing company and I get exclusive distribution just to me. And then I realize, I don't want to stay in this industry anymore. I can assign my rights under that contract to someone else. Questions about bad faith, how it works, what we're trying to do when we're doing these demand letters. Because I think if we're just thinking, oh, we want to send the demand and we hope we get the policy limits, right? That's really kind of small thinking. We want to be thinking a couple steps ahead. How do we set this up to where to deny this demand would be unreasonable? How do we set up those scenarios? How do we make sure that our demand is so solid, has all of the information, is so reasonable that if they were to deny the policy, it would be unreasonable? Because now, if we do that, we have an open policy, and that just, the sky's the limit. And even if we go to trial, we have an open policy and our verdict is less than that open policy, who cares? I mean, obviously we want to get the most for the clients, but we get a reputation within the insurance industry that these guys know what they're doing and they'll go the distance.
Got crash? Don't get mad, get paid.